So the dragonlance lawsuit has been voluntarily dismissed by the plaintiffs Hickman and Weis. What does that mean? Why did it happen? What are my thoughts on it? Let's talk about it. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about the dragonlance lawsuit, which we've talked about before, between Margaret, Weis, Tracy, Hickman, co-writers of the Dragonlance books, and basically co-creators of the Dragonlance universe in Dungeons & Dragons, versus Wizards of the Coast over an upcoming proposed deal to release 3 more Dragonlance books in the same sort of timeline as the Dragons of Autumn Twilight, Winter Morning, and Spring whatever. I can't remember what the exact titles are, but you know, if you know about these books, you know what the titles are, you know what the books are, and these are kind of iconic D&D books. Now, earlier this year, Weis and Hickman filed a lawsuit alleging a proposed breach of contract by Wizards of the Coast. Basically, they said Wizards hadn't quite breached the contract yet because they kind of can't the way it's structured, but it was a constructive breach of contract because they were preventing the actual books from having the possibility of being released. And the way they were doing that, according to the lawsuit, the way they were doing that was to not give final approval. As the owners of the Dungeons & Dragons IP and the Dragonlance IP, Wizards of the Coast had basically, in their license agreement to Weis and Hickman, had said, we have to have ultimate approval over whatever you're writing. This is very sort of common standard stuff when you're licensing out a property for someone to do some creative work with that property, be it art, be it video games, movies, television, it doesn't matter. You tend to have creative control over the IP itself. And so they retain that creative control by saying that they would, provide either approvals or denials of proposed manuscripts. And if the key part that was alleged in the lawsuit, that if they had given a denial over a proposed manuscript or a section of the manuscript, that they would provide what steps needed to be taken to grant approval on a subsequent rewrite. And that was very important. So they didn't have the ability in their contract, again, according to what was alleged in the lawsuit, to just flat out deny anything. They could deny it, but they had a duty then to provide some sort of idea of how to remedy the problem. What they alleged in the lawsuit was that there was a phone call in which Wizards of the Coast came in and said, we're just not going to approve anything ever again. That's a constructive breach of the contract. That was the ultimate claim, and it prevented them from releasing any of the novels, one of which is apparently already done. But it prevented them from releasing any of the 3 novels, and of course, then reaping the consequent income from those novels. And they had already put apparently about a year of work into creating the first one, and were well on their way into the second one. So this is a big deal. This is a multi-million-dollar lawsuit because it involves major books that will have a major release and stood to make quite a bit of money. But it has now been dropped by the plaintiffs with no action by the defendants. So why does this happen? Well, we don't know, but we can make some guesses as to what this means. And my guess is that this is very, very good news for Dragonlance fans, for Dungeons & Dragons fans, for people like me who wanted to see these books come out. I think now we're going to see the books come out. Whereas if this lawsuit went through all the way, it seems like that was probably not going to happen. If the lawsuit went all the way, we would probably see Weis and Hickman being compensated for the books never getting printed. They would have to have, what was in their contract paid out to them or something like that, some sort of remedy along those lines. Now, with them voluntarily dismissing this, even though Wizards of the Coast has had no action in the case, that probably means they've been doing what I kind of suspected a little while ago. I didn't really talk about this in an independent video. I believe I mentioned it on a live stream, but Wizards hadn't responded in any way to their suit. They didn't even file a return of service at the time that I had looked, and it was getting to be a little bit late in the process. And my thought was, I bet they're negotiating this out. Wizards does not want to fight this lawsuit. If the allegations in the complaint were even close to true, Wizards was going to get manhandled, and it was going to be very, very bad for them, both from a PR standpoint and from losing the income and the losing the property of the books in general. So that was going to be a very messy thing, and it was going to tick off a lot of fans. So I thought maybe they were involved in talks negotiating this out. A friend of mine who's a business attorney specifically says, you know what, the best way to resolve a business dispute is by doing more business. And hopefully that is the resolution they've come to. I think that's likely the case, as we'll see based on some statements from parties. And we'll take a quick peek over at that dismissal. Let's do that right now so we have that in our mind for the article here. All right, notice of dismissal without prejudice. This is Weis and Hickman doing the notice of dismissal. Pursuant to Rule 41A1AI of the Federal Rules of Civil Procedure, plaintiff Margaret Weis, LLC, and Tracy Hickman hereby gives notice that the above-captioned action is voluntarily dismissed as to Wizards of the Coast, LLC, without prejudice. Defendants Wizards of the Coast, LLC, has not filed an answer or a motion for summary judgment. No proceedings or discovery have been undertaken as these claims, and this action is not subject to any federal statute which would preclude the dismissal of the action under Rule 41A1AI. Now, the reason they mention that they've taken no action here, that's not some sort of weird like judgment or slight or anything towards Wizards of the Coast. What they're doing is informing the court that there is nothing that will hold up the voluntary dismissal without prejudice. It means that Wizards hasn't undertaken at the court level any sort of burden that the court would want to remedy. Like if you bring a lawsuit against someone and then they go through a whole bunch of work, they hire a lawyer, they draft up a bunch of responses or motions to dismiss or a motion for summary judgment, and they spend, $10,000, $20,000 getting that together. And then you're like, whoa, actually, you know what? I don't even want to sue him anymore. I'm just going to go ahead and wipe this out. The court doesn't think that that's ultimately that fair. That would allow plaintiffs to file lawsuits that they had no intention of carrying out, cause the other party to experience loss, and then back out of them. So they won't always grant that dismissal if the other party has undertaken something, unless the other party were to consent to it. They reach some sort of settlement. So that's what they're doing here. They're not making any sort of statement about Wizards of the Coast and their action. They're just merely informing the court that there's nothing that's going to get in the way of this voluntary dismissal, and the other side hasn't suffered any harm or loss at the hands of Weis and Hickman, at least as far as things the court can fix is concerned. All right, so let's take a look at what Comic Book says here, comicbook.com, and I'll have a link to this in the description if you guys want to check out the article. I don't know if we're going to get through the whole thing. It's not a very long article. A surprising lawsuit involving the seminal writers of Dragonlance novels and the parent company of Dungeons & Dragons has seemingly ended. Well, I mean, it has ended. It's not seeming. It did. It was dismissed and terminated on the 18th of December. Last week, Margaret Weis and Tracy Hickman, primary authors between the popular Dragonlance novels, filed to voluntarily dismiss their lawsuit against Wizards of the Coast. Weis and Hickman filed a lawsuit in U.S. District Court earlier this year, alleging that Wizards of the Coast breached a licensing contract to write a trilogy of new Dragonlance books by informing the pair's publisher they were no longer moving toward the books without explanation. The duo, who claimed that a Dragonlance novel was already completed, and that substantial work had begun on a second book, sought up to $10 million in damages in the initial lawsuit. The filing noted that Wizards of the Coast had not formally answered their lawsuit, nor had they filed a summary judgment. As Weis and Hickman filed for dismissal without prejudice, the duo could hypothetically refile their lawsuit at a later date. Yes, they can do that since it is without prejudice. The injury may still exist. As we discussed before, in the same way that they don't want plaintiff causing harms to defendants through frivolous lawsuits and then, withdrawing claims after filing them. They similarly don't want defendants agreeing to something or giving the plaintiff some reason to believe that the dispute is resolved, and then having the defendants again just refuse to proceed. They don't want deception to be governing the relationship between these two parties. So they will allow them, if they want to bring the action again, to refile again. That's what's dismissed without prejudice. Weis commented on the dismissal on Twitter, noting that fans should look for some exciting news in the coming weeks. Margaret says, I know some of you have seen that our lawsuits against Wizards of the Coast was dismissed. I can't say anything yet, but watch for exciting news in the weeks to come. And thank you so much for your support. And again, I think this is indicative of a very likely agreement between Weis, Hickman, and Wizards of the Coast that they will go ahead and go forward with the Dragonlance books. Heck, they might even be bringing them into the fold on some other projects as well. There is, as it goes down, there's mentioning that he has this guy, Joe Manganiello, I don't know his name, mentioning that he has 5th edition stat blocks for Draconians. So there may be some full-on Dragonlance property coming out very soon that goes even beyond the books, but maybe a 5th edition campaign setting or expansion or adventures of some sort in the Dragonlance section of the universe might be on the way. So that is great news for Dragonlance fans, great news for D&D fans, probably great news for Wizards of the Coast, who, in my humble opinion, look to get absolutely spanked in this lawsuit if the allegations were even close to remotely true. And coming from seasoned professionals like Weis and Hickman, it seemed unlikely that the allegations being made were not true. They would also have been pretty easy to fight back against publicly by Wizards of the Coast if there wasn't at least some substantial truth to those claims. And that would have been a really sort of ugly drag out fight for them, and it probably would have ended with no Dragonlance books, a big loss of money to Wizards of the Coast, and a bunch of angry fans. And that would have been all around bad. So it looks like they've resolved this. Let's keep a watch on it. Hopefully that is true. I would love to see some Dragonlance materials come out for 5th edition. Hope you guys like this video. Learn something about the legal process, negotiations. I don't know, maybe. If you do like this stuff, please hit like, please hit subscribe, hit that stupid little bell notification so that you tell YouTube that, no, really, I do want to see when videos come out. And then share this with other people who are interested in law, who are nerds, or even who are law nerds, and have them learn something about this D&D lawsuit as well. Hope you guys enjoyed it. Have a great day. Talk to you soon. Peace. Peace.